Good morning, afternoon, whenever it is. Not legal advice. Please like, subscribe, share, comment. I do review comments. Show it to your animals, your pets, and your plants. I know that ficus trees really like these videos. At least I've been told that. Today I'm going to talk a little bit about the new alpine lawsuit that's ongoing in Utah against the DTCC and the NSCC, who do clearing for the entire stock market. But before I start with that, I had just a couple quick comments. And by the way, don't rely upon anything that is said in here, just my impressions, experience, etc. Hopefully it will stimulate people and maybe provide some information that's helpful, maybe. What is a, and since we're talking about Alpine, I decided to do some jokes related to thieves. No correlation there, of course. What is a thief's favorite kind of music? Of course, rob and roll. Why did the thief take a bath before he robbed the bank? Because he wanted a clean getaway. And of course, and listen to this one carefully, I'll say it slowly. Why did the tomato turn red when it caught the thief? Because it saw the salad dressing. Anyway, moving on to Alpine. So Alpine is the prime broker involved with GTII. There has been a lot of activity regarding Alpine and its history. I've gone through a litany of occasions. It's been penalized, disciplined numerous times, including violations of the Bank Secrecy Act, stealing money, trying to get a convicted sex offender, being the representative of the company, etc., subject to a current cease and desist action on appeal in DC currently. And somebody pointed something out to me, and I kind of followed it. And apparently, there's an action in Utah in federal court. And ironically, the DTCC and NCC, who do basically all the clearing for securities in the U.S., they were involved and have been involved with Alpine. I guess there's been prior incidents involving Alpine, concerns about margin requirements, etc., rule changes. Alpine has objected, and there's been disputes, and Alpine has contested the ability of these organizations to impose new requirements and lost. So apparently in 2022, there were new requirements imposed for excess capital. So that required members who were doing clearing, which Alpine does, self-clearing, clearing for other microcaps, and I think clearing for Scottsdale, as it turns out. So those companies are members of these associations. Association passes rules to protect the clearing process, including imposing capital requirements. So I think it's in 2022, effective 1 year later, they imposed new capital requirements, in part based upon risk. And it's called the ENS, which is an excess capital requirement. It means you have to have this amount available just in case of disaster or emergency. And the amount that was imposed, because Alpine was deemed to be a high enough risk, was $10 million. They had to have that on hand just in case. I don't know where they got that money, by the way, or if they got that money. But they were aware of this for about a year, and then they also indicated, and this is based upon my review of the pleadings, there's a file, and I reviewed those pleadings. But they were aware of that for a year, and then their general counsel indicated that they knew that if they didn't comply, that they could be kicked out, and that would have ramifications as such. And then about 2 days before the actual rule was implemented, which is October of 2023, they bitch and moan and raise a hullabaloo. They don't comply. Not only do they not comply, but what they do is they say they can comply. They misrepresent their ability and access to capital. It turns out to be false. As a result, amongst other things. And because of the risk, because they don't have the capital there, and I don't know where they're getting any capital. I don't know how they're paying legal fees. I don't know who's paying legal fees. We know they've been hit for violations of the Bank Secrecy Act related to money laundering. That's what that purpose of that act was. But I don't know where they're getting all this money to contest all these proceedings. Who is paying the money? But anyway, so the NSCC and the DTCC combined jointly, they initiate a disciplinary proceeding against Alpine, and I know we've heard this before. And Alpine files a lawsuit, and the lawsuit seeks an injunction to block the disciplinary proceeding. And the lawsuit, seemingly analogous to what's going on in D.C. against FINRA, claims a bunch of constitutional violations, claims these entities are private actors, and there's a violation of separation of powers, appointments clause, due process, all constitutional provisions. So they assert that, file a lawsuit. Eventually, and it's in communication, this is not done unilaterally. There's communication between these agencies and Alpine, and a hearing date is set for basically Alpine's expulsion from these clearing firms, which hopefully would shut down their business. And the date for this particular disciplinary proceeding, which would be before a three-judge, not a three-judge, a three-hearing person panel, is March 18th, 2024. So that's about 2 weeks away. And they would look to see if there was compliance with the rules and that the clearinghouses themselves complied with their own rules, and they'll see if Alpine has any leg to stand on. And if they find that Alpine should be removed, that order would probably be effective about 10 days after, but Alpine could take that up to the SEC or the Court of Appeals. So it's not final, but it's partially final, and it shows you on their way. And especially since it involves risk to the marketplace, it would seem like this would be a issue that would be carefully watched and important. So Alpine has a proceeding going against it, and what does it do? It seeks an injunction. So files a motion for an injunction. I think it's filed about February 20th. That basically claim the constitutional violations that I mentioned. They also claim that if the proceedings go on, they'll suffer irreparable harm, which is a requirement of an injunction. The opposition to that says that these agencies are not state actors. They're not bound by these constitutional provisions. The SEC is supervising. They're providing adequate supervision, and Alpine's a risk, and they misrepresented their financial means. Not the first time. There's other regulatory issues, and they want them out. And that all that is occurring now is a hearing that can be reviewed. So there's no irreparable harm or threat of that, and their injunction should be denied. And there was a brief response from Alpine, I guess, objecting to that, but not making a very sound argument. Hearing on this matter occurred yesterday, but no ruling has been issued. So the hearing on the injunction occurred yesterday. If the injunction is granted, then the disciplinary proceeding on the 18th will theoretically go forward against Alpine, and these agencies will try to get them kicked out. If the injunction is denied, in light of what Alpine did in DC, wouldn't be shocked if they filed an appeal in Utah, where this case is pending, and they would seek a stay of any further action. Whether the appellate court in Utah would grant that or not, I don't know. Again, I'm going to go back to this. Alpine is spending millions of dollars in legal fees. They got fined for the Bank Secrecy Act violations just alone, $12 million. There's reference that they were loaned money to meet this capital requirement. Who loaned them money? And I know there's been discussion recently about maybe the SEC has kicked them out. I don't know. I would expect if that's happened, we will see it. But what's interesting is apparently there was communication by John Hurry, at least that's what I heard, where he indicated that everything from Alpine had been moved over to Scottsdale. But if everything from Alpine had been moved over to Scottsdale, why is Alpine therefore now spending millions of dollars in legal fees trying to protect the business arrangement of Alpine? Makes no sense unless Alpine does not want the government to have access to what they have been doing in terms of their business and have concerns about what would happen, because otherwise it makes no sense for Alpine to spend millions and millions of dollars. It's a small company. It obviously cannot afford that. Couldn't afford to put up the capital, the 10 million in capital. So how could it pay the fine? How could it conduct business? How could it pay the millions of dollars in legal fees? Again, remember they were convicted of thousands of violations of the Bank Secrecy Act. Something is foul here. The courts are pressing, and all these agencies are pressing on them. Again, just a matter of time. As soon as I hear the ruling that came out or that will be generated by the court on the hearing that happened yesterday, I will let you know. And that will bring you up to speed. Hope that brings you up to date on these scumbag Alpine guys. Just another attack on them. They're going down, just a matter of time. There really is no defense for their conduct. They're just delay. That's their defense. And why would they delay and spend money unless they had something to hide or were doing something underhand? Makes no sense otherwise. That's the logical conclusion. Anyway, everybody be well, take care. Hope this was informative. Talk to you later.